afternoon. Welcome to this week's Cape Breton Realty Weekly Update. My name is Everett Vass, and unfortunately Sherry was called away on some urgent matters, so it's going to be me providing the weekly update this week. And what we thought we would do is go into a little more detail about the various conditions of entering into a relationship with a realtor that exists in Nova Scotia under the laws that we have governing real estate. And the first form that you will encounter when you are entering into a relationship with a licensed realtor or a brokerage representing a seller or buyer is the working with the real estate industry form. And there's a few concepts that I wanted to go over that will give you some information about what's the expectation when it comes to yourself as a buyer or a seller, and also the brokerage that you're dealing with, or the real estate representative involved in your transaction. So the first thing to understand is that in Nova Scotia, we have what's called a two-agency model for real estate brokerage. The first is the common law model, and the second is the designated agency model. Where these two are different, and each brokerage will be either or, a common law agency or a designated agency governed type of brokerage. The differences is that under common law, agency is with the brokerage, and all real estate representatives licensed with the brokerage represent all the clients of the brokerage and are deemed to know all relevant information about those clients. So that's the first distinction, is that under common law agency, that the brokerage is assuming that our agents know everything there is to know about all of the represented clients that we have. The difference is with the designated agency. Under designated agency, the agency relationship is only with the designated agent specified in the agreement that exists between the brokerage and the individual client. It's not with the brokerage, and not with any other real estate representative licensed by that brokerage. So there is the first major distinction between common law and designated agencies. The other important thing to understand is what is agency, and what does that mean if you are in an agency relationship, either via common law or as a designated agent type of agency. Well, the first distinction is that we make is that if you are a client, the agency model that is dictated by that relationship is that the real estate representative works with the clients in a legal relationship that is called agency, and as the client, the agency relationship exists between you and the brokerage under common law agency, or between you and the designated agent under designated agency. The essence of agency relationship is that the brokerage and or the designated agent has the authority to represent you as the client in a real estate transaction with others. So that's an important distinction. So the client relationship is defined as follows. Brokerages and or designated agencies are legally obligated to protect and to promote your interests. Your real estate representative has the following duties: to protect and promote your negotiating position at all times, to disclose all relevant facts about a property or a transaction, including any material latent defects, to obey all your legal instructions, to provide undivided loyalty, to act in your best interests, to keep your confidence, to exercise reasonable care and skill in performing all assigned duties, and to account for all money and property placed in their possession while acting on your behalf. In addition to these fiduciary, what are called fiduciary responsibilities, your real estate representative will also explain real estate terms and practices and provide and explain the forms that we use to transact business, and identify and estimate service costs of all professionals involved in the transaction. They will assist you with the negotiation. They will prepare offers and counter offers at your direction. They will present all the offers received promptly and give you true copies of all the agreements. So that's part of the obligations under a client relationship. Now the difference is now with a customer relationship, it doesn't have the same notions of agency, but here is what a customer relationship is all about. A buyer or a seller may choose to use the services of a real estate representative without agency relationship. So under a customer relationship, there is not the sort of the fiduciary responsibilities that there is under a client relationship. For example, this might occur when a real estate representative is showing you their seller client's property, or when they approach a seller directly on behalf of their buyer's client. So in this relationship, the real estate representative has a legal and ethical duty to provide accurate and honest answers to any questions, and can provide the following services. For example, explain real estate terms and practices, identify and estimate service costs of other professionals involved in the transaction. But the real estate agent under customer relationship definition cannot do the following. They cannot provide utmost loyalty to the buyer and the seller. They cannot act in the best interests of either the buyer or the seller. They cannot offer advice or recommendations to either the buyer or the seller, and they cannot disclose confidential information learned in the previous conversation with either the buyer or the seller. So all of these things play into the relationship that you will have and the agency and the fiduciary responsibilities of your broker, your representative, and yourself over the course of the relationship. There's also a notion of privacy and use of personal information that you should be aware of. So real estate representatives respect the privacy expectations of consumers and the requirements imposed by law. But real estate representatives are required by federal law to collect information and confirm the identity of buyers and sellers. So in the course of our transaction, we will ask for information to confirm the identity of you if you're acting as a buyer or a seller. So you will be asked to agree to the fact that you understand that the brokerage and real estate licenses have an obligation to comply with the provisions of the Nova Scotia Real Estate Trading Act, for example, and the Nova Scotia Real Estate Commission bylaws, and that this may include providing personal information to the Nova Scotia Real Estate Commission for the purposes of audit, inspection, review, and related purposes. So you must, in the end, consent to this disclosure of your personal information in order to transact a real estate transaction, a deal. And then this information is kept for 7 years. So another provision of the agreement is that the real estate representative retains that information in the brokerage, by their brokerage, for at least 7 years. So that is the length of how long personal information is kept on file relating to transactions that you have been involved with. So that gives you an idea, just basically some of the notions of privacy, some of the notions of agency, some of the notions of common law, as well as some of the notions of designated agency that exist within real estate in Nova Scotia. So I'm going to leave it at that for this time, and wishing you all the best and a very great holiday season, Merry Christmas, and a Happy New Year. We will drink with a little bit of Fiddler's Choice. Sláinte. We'll see you all in the new year. Thank you.